School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 3 Business Contracts, Unit 5 General Principles of Contract, Part 2.
Performance of the contracts. Both the parties to the contract either perform or offer to perform their respective promises until such performance is dispensed with or excused under any provisions of this Act or any other law in force. Even the death of one of the party makes his legal representatives liable unless the intention of the parties to the contract differs. The promisee's non-acceptance of offer of performance of the promiser. The promisee's non-acceptance of offer of performance of the promiser. The promiser is not responsible for the performance, nor does he loses his rights under the contract subjected to certain conditions. They are: number 1. The offer must be unconditional. Number 2. It must be made at a proper time and place and in the circumstances that the person to whom it is made must have a reasonable opportunity to ascertain that the person is able and willing to do, that is, accept. And number 3, if it is the delivery of anything to the promisee, he must have an opportunity of seeing the delivered thing which the promiser is bound by his promise to deliver. In case of anticipatory breach of contract by the promiser, the promisee may put an end to the contract and sue for damages immediately, though he had a right to keep open the contract until the performance is actually due. Keeping the promise alive may lead the promiser to take advantage of supervening circumstances. The performance by the person who makes the promise, the promiser, or his representatives may employ a competent person to perform depending on the intention of parties to the contract. If the performance from the third person is accepted by the other party, later the promisee can't enforce against the promiser. When the promise is made jointly, it is to be performed by all such joint promisers during their life and after the death by any of them or his representative jointly with the surviving promisers. After the death of the last survivor, the representatives must fulfill the promise jointly. This is subject to a contrary condition of the contract. The promisee may compel one of the joint promiser to perform in the absence of express agreement to the contrary. On such performance by one of the promiser, he can compel the other promiser to contribute. In an occasion where one of the promiser failed to contribute, the remaining promisers have to share the loss of contribution. This is also subjected to a contrary and appears in the language of the contract. The release of the joint promiser from performance does not discharge the other from liability. There is a point of difference in English law and Indian law. In India, they are presumed to be jointly and severally liable. When a party makes a promise to two or more persons, the right to claim the performance rests between him and them, with them during the lifetime of the parties, and on the event of death of either party between the representative and survivor or representatives as the case may be, with joint promisee or survivor or representative or representatives. This is subjected to a contrary condition of the contract. Time and place of performance. When the promiser has to perform without the application of the promisee and no time is specified in the contract to perform, the performance must be done within reasonable time. What is reasonable time is a question of fact. When the time is specified but no application to be made by the promisee, the promisor may perform it any time during the usual hours of business on such day and the place at which the promise ought to be performed. It is the duty of the promisee to make the application for performance on certain day to be at a proper time and place during the usual hours. What is proper time and place is a question of fact. It is the duty of the promisor to make an application to the promisee as to the time and place to perform when a promisee is to be performed without application. The promisee may prescribe or sanction the manner, the time, and place of performance. Performance of reciprocal promises. In case of existence of reciprocal promises, the promisor needs to perform only when the promisee is ready or willing to perform his part of promise in the contract. The reciprocal promises are to be performed as per the order specified in the contract. In the absence of such specification of order, they must be performed in the order of the transaction requirements. The party preventing the other ready to perform his part of the reciprocal promise, the contract becomes voidable at the option of the party so prevented. He is entitled for compensation for loss because of non-performance of the contract. The order of the performance of the reciprocal promises is in the sequence as specified. The non-performance does not entitle the performance of the reciprocal promise and must make compensation to the other party for any loss because of his non-performance of the contract. The performance to do a thing at or before specified time has to be performed accordingly, failing which the contract becomes voidable in case the contract specifies that the time is essence of the contract. The intention of the contract does not specify time as essence of contract, then the contract is not voidable and the promisee is entitled for compensation for any loss because of non-performance of the contract. If the promisee agreed the acceptance of performance by the promisor other than at the agreed time, he can't claim damages for the delay in performance. However, he is entitled for compensation if he gives notice to the promisor of his intention to do so at the time of acceptance. Doctrine of frustration or agreement to do an impossible act. The agreement between two parties to do an impossible act itself is void. A contract may also be void because of an event which makes the performance of promise impossible or unlawful after the completion of the contract. Any person who makes promise to perform by knowing it to be impossible or unlawful is liable to pay compensation to the promisee that is not aware of impossibility or unlawful nature of the contract at the time of arriving it. This is known under the doctrine of frustration. This will be applicable in two classes of cases. They are: number 1, where a supervening event makes the performance of a contract impossible, and number 2, where a supervening event or events have frustrated the object of both the parties and the changing circumstances fail the promise to be performed. The dislocation of business in the wake of the First and Second World Wars brought before courts a large number of frustration cases, and it has now been recognized the term frustration includes the cases of impossibility as well as the frustration of adventure. Supervening impossibility. The very object of the subject matter relating to the contract disappears. The contract is discharged by frustration on the ground of destruction of subject matter. A contract is also considered as frustrated in case of non-occurrence of expected events. The musician who failed to perform at the concert due to illness as agreed in a theatre was held to be frustrated and so discharged by supervening impossibility. The requisitioning of land by government for military purposes from the contract of sale of land by a company which undertook to construct drains and roads on the land to make it suitable for residential purpose is not considered as supervening impossibility, as it was a temporary interruption and does not discharge the parties from the performance of the contract. Supervening illegality. The contracts entered with the enemy nationals prior to the outbreak of war are suspended during the war and revived after restoration of peace only if it is not a continuous mutual duty between the parties. The changes in law also make the contract unlawful and the performance of the contract impossible. The judiciary expressed different theories for the judicial basis on the subject. The implied theory propounded by Viscount Simon says that no term could be implied to put an end to the contract in those circumstances. According to the disappearance theory, if the foundation of the contract disappears either by the destruction of the subject matter or by reason of interruption of performance, it must be regarded as frustrated. In case of just and reasonable solution theory, even the express term in the contract render the performance impossible and the contract purporting to be alive, courts may hold the parties discharged from liability under the doctrine of frustration. Doctrine of frustration limitations. The party who is himself responsible for frustration can't invoke the doctrine. This doctrine is not applicable to leases. In England, this doctrine is not applicable to the contract of sale of land as the buyer becomes the equitable owner of the property. In India, there is no equitable estate as such, and so the doctrine is applicable even to contracts for sale of immovable property. When there are two sets of reciprocal promises between the parties, one is legal and the other is illegal based on the circumstances. The legal one becomes a valid contract and the other is a void agreement. In case of alternative promises, the legal one can be enforced and the other is void. Appropriation of payments. When the payment is made by the debtor, the payment has to be remitted by the creditor towards the amount outstanding as suggested by the debtor. If the debtor had not specified to which debt the payment had to be adjusted, the creditor had a right to pay even the time-barred debt also. Neither the debtor or creditor appropriated the payment made by the debtor. The payment must be adjusted towards the first debt which is outstanding between the creditor and the debtor. These rules for the appropriation of payments are known as rule in Clayton's case. Contracts which need not be performed. The original contract between the parties need not be performed in case of novation, rescission, and alteration of such contract. If the parties agree to substitute a new contract instead of the original one, or to rescind or to make an alteration of the contract, the parties to the original contract need not perform the obligations therein. The promisee is at liberty to dispense with performance of the promisor wholly or partly, or extend the time of performance, or may also accept instead of it any satisfaction which he deems just. When a person having the option of rescinding the voidable contract exercises his option to rescind, the other party need not perform his part of promise in the contract. Further, the party rescinding receives any benefit under voidable contract is liable to restore the benefit to the other. When a contract becomes void afterwards, the party deriving benefit or advantage of such contract is under obligation to restore it. In case of rescission of a voidable contract, the party exercising the option must communicate the rescission of contract in the same manner as followed for communication of the revocation of the proposal. The neglect or refusal of the promisee to afford the reasonable facilities for the performance of the promiser is excused for the non-performance caused thereby. Of certain relations resembling those created by contract. These are also called as implied contracts or quasi-contracts or constructive contracts, which are created by lawyers and judges based on certain equitable considerations. The early common law of England had only two kinds of remedies, contractual and delictual. In the absence of contract, the remedy could only be in tort. Quasi is a Latin term which means as if. In quasi-contracts, there will be no actual contract between the parties, but the law attributes to a particular situation consequence which is similar to that of a contract. Action of account is the early quasi-contractual liability. This was available against bailiffs, receivers and guardians who had to account for money kept with them. The 14th and 15th century extend to every case where money is paid to the defendant by a third party to the use of plaintiff. The underlying principle to determine the liability of the defendant is unjust enrichment at the expense of plaintiff. The equity courts applied the principle of preventing unjust enrichment in evolving the concept of trust. There is no exact definition of a quasi-contract given anywhere, even in the Contract Act. Those given by Dr. Winfield and Dr. Jenks may be accepted in the absence of a better one. A delivers goods to B without any contract, either expressly or in writing. B consumed the goods delivered by A. The obligation of B to pay A the price arises from his promise implied by his conduct. This kind of contract is called a tacit contract. Similarly, if A delivers to C assuming him to be B and C consumed them, the obligation of C to pay compensation to A for their value is quasi or implied contract. The examples of quasi-contract are: number 1. Action for money had and received. This was based on the equitable principle that no person shall enrich himself at the expense of the other. Even the payments made under mistake of law may be recovered. The payment made under coercion is also recoverable under this principle. Number 2. Money paid to plaintiff for use of defendant. Where tenant A pays the taxes due from his landlord B to C in order to protect his possession from being processed against in execution of B's debt. In such cases, there is an obligation on B to repay the amount paid for his benefit. The enforcement of obligation under this head depends on two conditions, namely, the payment must be bona fide to protect his interest, and it should not be a voluntary one. Number 3. Quantum merit. The person deriving benefit from an act of another has to compensate the other even if there is no contract or invalid contract. This was based on the principle of quantum merit, which means as much as he deserves. The compensation is subjected to the phase that the delivery of goods is not made gratuitously and the defendant enjoyed the benefit. Number 4. Obligation of finder of lost goods. Though there is no contract between the finder and loser of the lost goods, the finder is having an obligation to return the goods fined to the owner as a bailee. Number 5. Necessaries supplied to a person incapable of contracting. This will discuss the contractual liability of a minor or lunatic to whom the necessaries are supplied which are suited to his condition of life. The person supplied necessaries entitled only to the property of the incapable party, but he can't make him personally liable for the dues of the supply. Consequences of breach of contract. Any Any party who is responsible for breach of contract is liable to pay damages or compensation to the other party who suffers loss because of non-performance by the other. In other words, the party aggrieved by the default of performance of the other's obligation leads to breach of contract and entitles him for compensation. There were two remedies available in case of breach of contract by a party. Number 1. Common law remedy, that is damages. The remedy of damages therefore only tries to evaluate in terms of money the loss which a party sustains as a result of breach of contract. And number 2, equitable remedy, that is specific performance of contract, injunction, rectification and cancellation, etc. Keeping in mind that specific performance is not available in every case, subjected to several limitations, there is no other alternative for courts than to award damages, which of course is available in every case. Measure of damages is the value of performance of the contract to the plaintiff and not what it cost the defendant to perform it. There are 4 kinds of damages. They are: Number 1. General or ordinary or substantial damages. These are the damages which ought to be paid as the consequence of breach of contract. In other words, it means the natural following consequences out of breach. Number 2. Special damages. These are the damages which ought to be paid for the loss of the profit in case of breach of contract of sale by the buyer. In other words, it was a kind of damages which ought to be paid on account of usual or extraordinary circumstances of the case. Number 3. Vindictive or punitive or exemplary damages. These are awarded with a view to punish the defendant. Generally, vindictive damages are not awarded in case of contracts, but will be awarded in actions in tort. But they may be awarded in contracts like breach of contract to marry and the breach of payment of the customer to honor the check. Number 4. Nominal damages. These are paid in case of technical violation but no substantial loss. Proof of damage is necessary even for claiming the nominal damages. The English law on the question of damages is laid down in Hadley v. Baxendale. The rules relating to the award of damages for breach of contract are: Number 1. The injured party is to be placed in the same financial position as if the contract has been performed. Number 2. Damages which are fair and reasonable arising from breach of contract can be recovered. Number 3. Damages which are contemplated in the contract at the time of contract can be recovered though they are not naturally arising. These are called liquidated damages. Number 4. Damages which will not fall under the previous 2 points but arise of special circumstances are called special damages and are not recoverable unless they are brought to the notice of the other party before the contract is made. Number 5. It is the duty of the aggrieved party to minimize the damages. Number 6. It should not be more than agreed amount of the damages. Number 7. The injured is not disentitled to damages because of difficulty to assess them. Number 8. Vindictive or exemplary damages can't be awarded except for the breach of contract of marriage. And number 9. The party rightfully rescinding the contract on the non-performance of the other is entitled to compensation. Now let's summarize the unit. The law that is applicable to mercantile transactions is called the mercantile law, which includes general contracts, special contracts, and the law of insolvency and bankruptcy. This law relates to the rights and obligations arising out of mercantile transactions between traders or merchants. Prior to the Indian Contract Act 1872, The English common law, with some modifications suited to Indian conditions for some time in the British India courts, was prevalent. A contract is an agreement enforceable in a court of law. An agreement is a set of reciprocal promises between the parties to the contract. These set of promises arise from an offer and acceptance from the parties to the contract. The contract may be express or implied, that is, it may be oral words or in writing, and even inferred from the conduct of the parties. It may be bilateral or unilateral contract. Generally, the contract completes when the acceptance of the offeree is posted or put into transmission. It was made at the place where the acceptance is received by the offerer. It was easy to determine the completion of contract when the parties negotiate in person. Consideration, capacity to contract, free consent, and legality of consideration and object are some of the essentials of a valid contract. The agreement between two parties to do an impossible act itself is void. A contract may also be void because of an event which makes the performance of a promise impossible or unlawful after the completion of the contract.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.